Colorado Real Estate Exam Trust Account Questions. Question 1. Skylar Mitchell has passed both broker exam portions and wants an active Colorado license. Which item must be in place before the license can become active? Option A. A signed property management agreement. Option B. A membership card from a private trade association. Option C. A county-issued home inspection permit. Option D. A current errors and omissions insurance policy. The correct answer is option D. A current errors and omissions insurance policy. Colorado requires E&O insurance before a broker can hold an active license. A management contract may be used in practice but is not a universal activation requirement. Trade association membership is private, and inspection permits do not activate a broker license. Question 2. Harper Imani is planning study time for the 2 Colorado broker exam portions. Which structure should the study plan reflect? Option A. A national portion and a Colorado state portion that most first-time applicants must pass. Option B. Only a Colorado law portion with no national part. Option C. A single oral interview with the commission. Option D. A continuing education quiz that replaces the initial exam. The correct answer is option A. A national portion and a Colorado state portion that most first-time applicants must pass. The broker examination has national and Colorado state portions for most first-time applicants. State-only testing may apply in limited recognition situations, but the initial path is broader, and the exam is not an oral interview or a routine continuing education quiz. Question 3. A complaint claims that Taylor Novak mishandled documents in a townhome transaction. Which authority can investigate Colorado broker license law violations? Option A. The county assessor because the property has a taxable value. Option B. The Colorado Real Estate Commission through its regulatory authority. Option C. The buyer's lender because financing was involved. Option D. A home warranty company because repairs may be needed. The correct answer is option B. The Colorado Real Estate Commission through its regulatory authority. The Colorado Real Estate Commission regulates broker conduct and can investigate license law violations. Assessors value property for taxes, lenders underwrite loans, and warranty companies provide repair-related coverage rather than license discipline. Stressed about your property and casualty exam? We can take property and casualty exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. Drew Jones becomes the employing broker for a Thornton office with several affiliated brokers. Which responsibility best fits that role? Option A. Guaranteeing every buyer's loan approval. Option B is setting county property tax rates. Option C. Supervising affiliated brokers, teams, assistants, records, advertising, and office policy compliance. Option D. Issuing building permits for renovated homes. The correct answer is option C. Supervising affiliated brokers, teams, assistants, records, advertising, and office policy compliance. An employing broker is responsible for supervision and brokerage compliance systems. Loan approvals are lender decisions, property tax rates are government matters, and building permits come from local building departments. Question 5. Logan Owens helps a buyer and seller complete a residential acreage sale without advocating for either side. Which Colorado brokerage relationship best describes that neutral assistance? Option A. Dual agency relationship. Option B. A supervising relationship for the buyer. Option C. Power of attorney relationship. Option D. A transaction-broker relationship. The correct answer is option D. Transaction-broker relationship. A transaction-broker assists with the transaction without becoming an advocate for either party. Dual agency is not the proper Colorado approach for adverse parties. Supervising creates agency under another broker's client, and power of attorney is a separate legal authorization. Question 6. A buyer asks Riley Kim to negotiate solely in the buyer's best interest. What must exist before the broker acts as the buyer's advocate? Option A. A written single-agent brokerage relationship with the buyer. Option B. An automatic transaction-broker relationship with no written agreement. Option C. A title commitment issued by the closing company. Option D. A verbal promise that the broker will try hard. The correct answer is option A. A written single-agent brokerage relationship with the buyer. Advocacy for one party requires an agency relationship created through the proper brokerage agreement. A transaction-broker does not advocate, title commitments address title issues, and a verbal promise is not enough to define agency duties. Question 7. Jamie Patel, a licensed broker, wants to buy a small warehouse personally. What disclosure is most important to make to the seller? Option A. The broker's favorite lender even when no loan is involved. Option B. The broker's licensed status and personal interest in the transaction. Option C. The broker's private tax return history. Option D. The names of every buyer who toured the property. The correct answer is option B. The broker's licensed status and personal interest in the transaction. A licensee buying or selling for personal benefit should disclose licensed status and personal interest. Preferred lenders, tax records, and prior showings do not address the conflict created by a broker acting as a principal. Question 8. Marlo Lane receives a $5,250 earnest money check for a single-family home contract. Where should funds belonging to others be placed? Option A. In the broker's personal checking account until inspection is over. Option B. In the brokerage marketing account for advertising expenses. Option C. In the appropriate trust or escrow account according to the contract and brokerage procedures. Option D. In a cash envelope kept at the property until closing. The correct answer is option C. In the appropriate trust or escrow account according to the contract and brokerage procedures. Money belonging to others must be safeguarded through the proper trust or escrow arrangement and documented. Personal accounts create commingling, marketing accounts are for business expenses, and cash envelopes do not provide acceptable accounting controls. Are you looking for Colorado real estate actual questions? Visit our website pokerexams.com to access Colorado Real Estate Study Guide with actual questions and answers. Scan the QR code or click the link in the description to get Colorado Real Estate Answer Key today. Question 9. A buyer and seller both demand the same $7,625 earnest money after a failed contingency. How should the broker holding the funds respond? Option A. Release it to whichever party calls first. Option B. Keep it permanently as brokerage income. Option C. Split it personally without telling either party. Option D. Do not release the money unilaterally, follow the contract, written mutual instructions, or a proper legal process. The correct answer is option D. Do not release the money unilaterally, follow the contract, written mutual instructions, or a proper legal process. Disputed earnest money should not be released without proper authority. First contact does not decide entitlement, disputed deposits are not brokerage income, and a personal split would violate the duty to account for funds. Question 10. Rowan Moore posts a video ad for a listing in Castle Rock but omits the brokerage name. Which advertising issue is most likely? Option A. The ad may be misleading because it does not clearly identify the brokerage behind the advertisement. Option B. The ad automatically transfers title to the viewer. Option C. The ad creates a mortgage lien on the property. Option D. The ad removes the need for a written listing agreement. The correct answer is option A. The ad may be misleading because it does not clearly identify the brokerage behind the advertisement. Real estate advertising should be truthful and identify brokerage involvement clearly. An ad does not transfer title, does not create a mortgage lien, and does not replace a proper written listing agreement. Question 11. A seller asks Sage Rivera to charge the same commission rate as every other brokerage in town. Which antitrust concern should the broker avoid? Option A. Explaining the broker's own office fee policy. Option B. Suggesting that commission rates are fixed or agreed upon by competing brokers. Option C. Negotiating compensation in a listing agreement. Option D. Telling the seller that commissions are negotiable. The correct answer is option B. Suggesting that commission rates are fixed or agreed upon by competing brokers. Antitrust law prohibits price fixing and agreements among competitors on commission rates. A broker may explain that broker's own fee policy, negotiate compensation, and tell the seller that commissions are negotiable. Question 12. A buyer asks Parker Nash to draft custom legal language giving unusual post-closing rights in a retail building. What should the broker do? Option A. Draft any clause requested because brokers may practice law during sales. Option B. Refuse to use any written contract for unusual terms. Option C. Use approved forms when appropriate and refer custom legal language to an attorney. Option D. Ask the title company to sign the clause for the buyer. The correct answer is option C. Use approved forms when appropriate and refer custom legal language to an attorney. Colorado brokers may use approved forms within their authorized role, but custom legal drafting should be handled by legal counsel. Brokers are not authorized to practice law for clients, unusual terms still need written documentation, and title companies do not sign contract clauses for buyers. Question 13. Cameron Stone signs a listing agreement for a mixed-use property but leaves the termination date blank. Why is that a problem? Option A. A blank date automatically makes the listing valid for 10 years. Option B. Termination dates are required only for commercial leases. Option C. The county assessor supplies the date after signing. Option D. Listing agreements should have a definite termination date rather than continuing indefinitely. The correct answer is option D. Listing agreements should have a definite termination date rather than continuing indefinitely. A definite termination date defines the broker's authority and avoids an open-ended listing. A blank date does not create a 10-year term. The issue is not limited to commercial leases, and assessors do not complete listing agreements. Question 14. In Avery Ortiz's contract for a mountain cabin, the inspection objection deadline passes without notice from the buyer. Why does that deadline matter? Option A. Contract deadlines control when a party must act to preserve specific rights or contingencies. Option B. Deadlines are only reminders and never affect rights. Option C. All deadlines are set later by the county recorder. Option D. The broker may extend deadlines alone whenever it seems fair. The correct answer is option A. Contract deadlines control when a party must act to preserve specific rights or contingencies. Colorado contracts use deadlines to define when objections, notices, and terminations must occur. They are not casual reminders. County recorders do not set private contract deadlines, and brokers cannot unilaterally extend deadlines for the parties. Question 15. Quinn Turner reviews closing instructions for a Greeley sale. What is the primary purpose of those instructions? Option A. To replace the purchase contract with a verbal agreement. Option B. To direct the closing company on documents, funds, preparations, and conditions needed to close. Option C. To create a new property tax assessment for the county. Option D. To authorize the broker to practice law for the parties. The correct answer is option B. To direct the closing company on documents, funds, preparations, and conditions needed to close. Closing instructions coordinate how the closing company handles documents, money, preparations, and closing conditions. They do not replace the purchase contract, set tax assessments, or expand a broker's authority to provide legal services. Question 16. Emerson Price asks when ownership of a duplex is transferred by deed. Which event is essential? Option A. Printing a marketing flyer for the property. Option B. Receiving a verbal value estimate from an appraiser. Option C. Delivery and acceptance of a valid deed. Option D. Ordering a home warranty before closing. The correct answer is option C. Delivery and acceptance of a valid deed. A deed transfers ownership when it is validly delivered and accepted. Marketing, appraisals, and warranties may support the transaction but do not themselves convey title. Question 17. Morgan Underwood finances a Colorado purchase with a $467,500 loan. Which document is the borrower's promise to repay the debt? Option A. Warranty deed. Option B. A settlement statement. Option C. Listing contract. Option D. Promissory note. The correct answer is option D. Promissory note. The promissory note is the borrower's personal promise to repay the loan. A warranty deed conveys title, a settlement statement accounts for closing charges, and a listing contract creates a brokerage relationship with a seller. Question 18. Reese Adams is selling a townhome with irrigation water rights near Arvada. Which Colorado principle is most closely tied to priority of water use? Option A, prior appropriation, often summarized as first in time, first in right. Option B, automatic ownership of all underground water by the newest buyer. Option C, equal monthly sharing among all neighboring parcels regardless of priority. Option D, federal flood insurance rules controlling every water diversion. The correct answer is option A, prior appropriation, often summarized as first in time, first in right. Colorado water rights are closely associated with prior appropriation and priority of beneficial use. New buyers do not automatically own all underground water, neighbors do not share equally regardless of priority, and flood insurance rules do not determine water minus right priority. Stressed about your Colorado real estate? We can take Colorado real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A landlord tells Finley Vega not to show a veil rental to applicants with children. Which law topic should the broker recognize immediately? Option A, a legal occupancy preference that overrides federal law. Option B, familial status discrimination under fair housing law. Option C, a zoning setback requirement. Option D, a title insurance exclusion. The correct answer is option B, familial status discrimination under fair housing law. Refusing applicants because they have children raises familial status discrimination concerns. Zoning setbacks involve land use, title exclusions involve ownership risks, and a landlord preference does not override fair housing requirements. Question 20. Jordan Brooks manages a rental in Colorado Springs and collects a $1,090 security deposit. Which responsibility is most important? Option A, use the deposit for brokerage advertising as soon as it is collected. Option B, treat the deposit as earned commission immediately. Option C, safeguard and account for tenant funds according to lease terms, trust rules, and applicable law. Option D, record the deposit as a deed in county land records. The correct answer is option C, safeguard and account for tenant funds according to lease terms, trust rules, and applicable law. Tenant funds and security deposits must be safeguarded and accounted for properly. They are not advertising money, they are not automatically earned commission, and they are not recorded as deeds. Question 21. A home built in 1942 is offered for sale, and Skylar Walker is preparing disclosures. Which federal disclosure topic should be remembered if the home was built before 1978? Option A, new minus construction warranty registration only. Option B, commercial securities prospectus delivery. Option C, flood insurance disclosure only because the home is older. Option D, lead minus based paint disclosure requirements. The correct answer is option D, lead minus based paint disclosure requirements. Residential property built before 1978 triggers federal lead minus based paint disclosure requirements. New minus construction warranties involve a different issue. Securities prospectuses are unrelated to ordinary residential sales, and flood insurance is not based only on the age of the home. Question 22. Harper Carter buys a property for $350,000 with an 80% loan minus to minus value loan. How much is the buyer's down payment before other closing costs? Option A, $70,000. Option B, $280,000. Option C, $17,500. Option D, $420,000. The correct answer is option A, $70,000. An 80% loan means the lender finances $280,000, leaving $70,000 as the down payment before separate costs. The loan amount is not the down payment, 5% does not match the stated ratio, and adding the down payment to the price double minus counts the obligation. Question 23. An investor asks Taylor Sue to estimate value for a rental producing $105,600 net operating income at a 10% capitalization rate. What value is indicated? Option A, $10,560. Option B, $1,056,000. Option C, $105,700. Option D, $105,600. The correct answer is option B, $1,056,000. Income capitalization divides net operating income by the capitalization rate, so $105,600 divided by 0.100 indicates about $1,056,000. Multiplying by the rate gives only a small fraction of income, adding the rate as dollars is meaningless, and dividing by 10 times the rate understates value. Question 24. Using a 360-day proration year, annual property taxes are $6,600, and the seller is responsible for 70 days. What tax debit should be charged to the seller? Option A, $6,530. Option B, $550. Option C, $1,283. Option D, $1,266. The correct answer is option C, $1,283. With a 360-day year, the daily rate is $6,600 divided by 360 and then multiplied by 70 days, which rounds to $1,283. Subtracting days from dollars is not a proration. 1 month of taxes ignores the stated days, and using 365 days does not follow the instruction. Question 25. Logan Young notices inconsistent square footage figures for a condominium in Broomfield. What is the best professional response? Option A, choose the largest figure because it helps marketing. Option B, hide all square footage information from the buyer. Option C, guarantee the number without reviewing any records. Option D, disclose the uncertainty and recommend that the parties verify measurements through reliable sources. The correct answer is option D. Disclose the uncertainty and recommend that the parties verify measurements through reliable sources. Conflicting measurements should be handled with disclosure, caution, and verification. Choosing the largest number can mislead buyers, hiding information does not solve the problem, and guaranteeing an unverified figure creates unnecessary liability.